that this distinction must be justified as rationally related to a legitimate government purpose. This requirement prevents arbitrariness, which undermines the rule of law, and if distinctions are to be made, they must be a rational basis for them. We have looked at the responses by the respondents. The key submission is that the national government enjoys the prerogative and latitude to impose taxes as a means of achieving the objective of realizing the right to housing. They did not answer why the tax falls upon employed formal workers as opposed to other taxpayers or non-taxpayers. In Okello and another versus National Assembly and others, Odunga J stated that taxes need not look the same and selective taxes may be applied to different actors for different reasons, such as to address distribution and equity. Hence, the tax need not be similar to another for it to be rational and discrimination. We add that for any legislation to pass the rule of law test, it must have a rational connection to a legitimate government purpose. Otherwise, the tax legislation would be arbitrary and unconstitutional. It's therefore the duty of the state to provide a rational explanation for the manner in which the tax is involved. In absence of a rational explanation for the manner in which the housing levy was enacted, we can only conclude that the respondents took the easy path of least resistance, as taxing employees informal employment is easier. It is also the respondent's constitutional responsibility to create a broad, efficient, fair tax system that complies with Article 201(b)(1) of the Constitution and the taxes levied against persons in formal employment to the exclusion of all other than formal earners to support a national policy without a clear justification is discriminatory, irrational, and arbitrary in violation of 27(201)(b)(1) of the Constitution and therefore unconstitutional for those reasons. In the Court of Appeal, in Kenya Revenue Authority versus Waweru stated that explained the principle of unfair taxation under 201(b) as follows. On the issue as to whether the imposition of minimum tax results in unfair and contrary to Section 201, the threshold for fairness is ensuring that everyone bears their fair share of taxation and pays the correct amount, which is seen to be fair by vigorous pursuit of tax avoidance and evasion. The petitioners have assailed the housing levy on the ground that it will result in lowering salaries of judges, hence is in violation of Article 164 of the Constitution, as well as the commissioners and holders of independent offices in contravention of Article 258 of the Constitution. These provisions that protect the remuneration and benefits are intended to safeguard the independence of judges, of superior courts, commissioners, and independent officers by insulating them from attempts by the political branches to influence them by reducing or threatening to reduce their remuneration and benefits. The petitioners have not demonstrated how the housing levy directly affects the salaries and benefits of protected officers, state officers, and how it violates Article 160 and 258 of the Constitution in that regard. Our reading of Article 210(3) of the Constitution is clear. It provides that no law can exclude or authorize exclusion of state officers from payment of tax by reason of the office of that state officer or the nature of work of that state officer. The petitioner's submission on that front also fails on the ground that the housing levy is a general tax that applies generally to all taxpayers and to us included. So having considered all the matters placed before us, we now conclude as follows, and this is what we state. The Finance Act is a money bill within the meaning of Article 114 of the Constitution. However, it contains some matter that would not fall within the purview or incidental to a money bill, although this does not change its basic character and substance as a money bill. The specific extraneous matters identified by the court pertain to amendment of the Kenya Roads Board Act 1999 through Section 76 and 78 of the Finance Act, amendments to the Unclaimed Assets Act by Section 87 of the Finance Act, and repeal of Section 21 of the Statutory Instruments Act by Sections 88 and 89 of the Finance Act. These amendments are extraneous to a money bill and are therefore unconstitutional. That under Article 220 and 221 of the Constitution, estimates of revenue and estimates of expenditure are part of the budget-making process. The estimates of revenue were included in the approved estimates contained in the Appropriation Bill and the Appropriation Act of 2023, as published in the Kenya Gazette Supplement number 87 of 15th June 2023 and 98 of 26th June 2023, respectively. We also find that the purport of Article 96.2 as read together with Article 114 is that the Senate is precluded from considering a money bill, which is only introduced in the National Assembly. However, in the matter of the Speaker, the Supreme Court held that it is necessary for the Speaker of the National Assembly to agree on the nature of the bill, any bill prior to introduction in any House. Consequently, the failure of the Speaker of the National Assembly to seek agreement with the Speaker of the Senate on the nature of the bill prior to its introduction in the National Assembly, in our view, does not vitiate the resultant act, as such concurrence is not a requirement under Article 114 of the Constitution. We find that there is ample evidence that the National Assembly conducted sufficient public participation in respect of the Finance Act. The National Assembly, having heard the views of members of the public and industry stakeholder on the bill, is not precluded from effecting amendments to the bill before passing it. There is no express obligation on Parliament to give reasons for adopting or rejecting any proposals by members of the public. Nonetheless, we think that in enhancing accountability and transparency, it is desirable that relevant committee, after conducting public participation, gives reasons for rejecting or adopting proposals received. We have looked at Section 2 and 21 of the Finance Act that amended Section 35 of the Income Tax Act to introduce digital monetization, and we find that this is a tax on income, and it is permitted, and it is not unconstitutional. The digital asset tax is a tax on income, and it is not unconstitutional. The tax on winnings is a tax on income, and it does not violate the 4th Schedule, Part 2 of the Constitution, as it does not impair the functions of county government. We have also looked at Section 26 of the Finance Act that amends the 3rd Schedule of the Income Tax Act by introducing new bans, and these are matters that we do not consider unconstitutional. We've also looked at Section 33 of the VAT Act that introduces VAT on insurance compensation. We find that it does not violate Article 40, and it is not unconstitutional. We have looked at Sections 30 to 38 of the Finance Act, which amend Sections 5, 8, 12, 17, 34, 30, 34, 43, First Schedule, Second Schedule of the VAT Act, and we do not find them in violation of the Constitution. We also looked at Section 48 of the Finance Act, which amends Sections 2, 20, 28, and 14, First and Second Schedule of the Excise Duty Act, and by introducing Section 36(1)A and 36(A), and we do not find them unconstitutional. And we also have looked at the changes in tariff headings and rates under the Excise Duty Act, and we do not find them unconstitutional. And we find that the introduction of the Housing Levy amendment to Section 84 lacks a comprehensive legal framework in violation of Article 10, 201, 2010 of the Constitution. That levy against persons in formal employment to the exclusion of other non-formal income earners without justification is discriminatory and irrational and arbitrary, and in violation of Articles 27, 201, B1 of the Constitution. And flowing from those findings, we find as follows that, and these are our declarations, Section 76 to 78 of the Finance Act, amending Section 7 of the Roads Board Act, 87, amending Section 28 of the Unclaimed Assets Act, Section 88 and 89, repealing Section 29 of the Statutory Instruments Act, are unconstitutional, null and void. That Section 84 of the Finance Act violates Article 10, 2BC, 27, and 201 of the Constitution and is therefore null and void. That an order is granted prohibiting the respondents from collecting, charging, or otherwise the charge known as the Affordable Housing Act on the basis of the Section 84, and all prayers on the consolidated petition not specifically granted are dismissed, and this being a matter of public interest litigation, each party shall bear its own costs. And we thank all of you, all the councils who appeared before us, all the litigants who appeared before us, members of the public for keeping a keen eye on this matter, and we thank you all. It is part of your responsibility as citizens of our beloved country. Thank you.